The question is that the motion be agreed to. Jacinda Ardern.
Mr Speaker, thank you, Mr Speaker. It's my pleasure to rise and speak to the Child and Family Protection Bill as a member of the Select Committee which considered this bill. And I will say up front that Labor will, of course, be supporting this bill as we support any measures that are aimed at preventing and mitigating the harm of domestic violence. But I think it's probably also fair that I also state up front that we do continue to urge the government to take up some of the other opportunities and pre-existing legislation that sits around this incredibly important area, which to this date I don't believe we've had an adequate response from the government as to why they're unwilling to pick up some of the existing legislation on the order paper. And if I could just highlight some of those bills just briefly. The Domestic Violence Reform Bill in particular has not yet been progressed, and we have used the opportunity of the Minister appearing before Select Committee to question the reasoning behind that, and he has stated that there are insufficient resources within the Ministry to pursue that particular bill. In fact, he gave the same reasons as to why another piece of legislation that's already been passed by this House under Labor around the family court, a bill which gave the power for family court to use registrars to act as mediators to reduce court load, to caseload in the family court, and those provisions have not yet been enacted. And again, that particular scenario, I would have thought, would have ultimately saved time and money for the ministry, and so I don't understand the reasons that the government has given us as to why that hasn't been progressed. And also the SIFS number 6 bill is another one that I have a concern that still languishes on the order paper, but I might come back to that one because it does bear some relevance to this piece of legislation. Just going on to some of the differences briefly with the Child and Family Protection Bill and that of the Domestic Violence Act, because it does demonstrate where there are still some obvious differences between where Labor would like to see us going, because the Child Family Protection Bill has omitted 5 important clauses that were included in that original piece of legislation. One is around the definition of the age of a young person within domestic violence legislation, which is set out by the United Nations Convention on the Rights of the Child. Currently in this bill, a child is anyone under the age of 17. Labor has continued to push that should be lifted to 18 in line with our UNCROC responsibilities. And that's not just for domestic violence legislation, but that's also, of course, when it comes to the youth court. But that's an issue we continue to push for, and we may, of course, see some SOPs in that regard. Also, this bill doesn't provide the court with the power to direct attendance to an addiction treatment program. That provision there may have been more fitting for perhaps the earlier domestic violence legislation that we dealt with earlier in the year, but it didn't happen then, so I wish to raise it again now, as it's the opposition's prerogative to do. And also Labor's bill, our original domestic violence legislation, introduced a provision requiring any judge who declined without notice application for a protection order to at least provide written reasons for declining that application. And that would, of course, enable the applicant to decide whether to proceed on notice. I'd be interested in as to the reasons why. The government continues to put up a resource reason as to why we're not pursuing that provision when the work has already been done. The bill exists. And also Labor's proposal to make provision for applicants to be able to attend information sessions, providing advice on making effective use of protection orders, and providing advice on any social assistance that may be available. Now, this continues to be an issue that is raised almost every time we deal with domestic violence legislation. We saw it around the police safety orders, ongoing concern from both NCW and Women's Refuge, that when we are using these tools of the law, that we need to provide women with adequate information and support to navigate through the system, because it's an incredibly difficult process that they then undertake when they enter into our criminal justice system to pursue these forms of protection. And unfortunately, I am hearing reports in Auckland in particular, that the police safety orders, those wraparound services are not being provided. Women fear taking police safety orders out because of the fact that it is a temporary thing. This was always a concern discussed by the Select Committee, but our view was that we could mitigate against that if women were then provided the support to pursue a longer-term protection order while the police safety order was covering them for those 5 days. Unfortunately, it seems anecdotally that's not happening, and perhaps we as members of this House should be investigating that in our electorates. But as the Minister has pointed out, we are talking about an incredibly large number of incidents that we're dealing with through legislation like this. In 2008, police responded to over 82,000 incidents dealing with domestic violence. So although I do express my reservations the government isn't going far enough on pre-existing bills that have been drafted, I am still pleased that we have this bill before us at this time. I thought it might be useful just to talk in a little more detail about one of the clauses where there has been some disagreement between government members and opposition members. And it probably in some ways wasn't the most significant part of the bill. It just so happened to be the one that there were divergent views on, and that was the extension of protection under the Domestic Violence Act. It was Clause 6 of the bill, which amends Section 16 of the Domestic Violence Act and clarifies how protection orders work for a child of an applicant who is under the age of 17. Now, the bill, as it stood when it came to us, only covered a child up into that age and then immediately expired, regardless, that's 17, not 18, regardless of where that child resided. So even if they were still in the home and under the care of the individual who took out the protection order, their age meant that that protection order would expire for them. We decided that it would be useful to ensure that it goes beyond that age if that child ordinarily, or the words that we use periodically, continues to reside with the applicant. And I think that was a good decision by the Select Committee. However, Labour and I believe the Greens advocated that that go further. It was our view that if a child who ordinarily is covered by a protection order chooses to leave home, that actually in many ways they become more vulnerable, not less, when they go out and live independently. So it was our view. We agreed with a number of submitters that suggested that protection orders should continue to apply to a young person after they turn 17, whether they reside with the applicant or not, and that in fact protection should be maintained until a young person themselves decides that a protection order is no longer required, because opting out of a protection order is much simpler, much less bureaucratic than a young person having to then pursue a protection order in their own right. So we will be putting forward an SOP on that matter. Also, we will, as we continue to do, we'll be putting forward an SOP on the issue that this should apply to those up to the age of 18, not just 17, in keeping with UNCROC. But I do want to very briefly mention the SIF's number 6 bill, which was introduced in December 2007, because I think it goes to the heart of some of the issues around care and protection of children generally. Timely, the Children's Commissioner today released a report, an interview of over 5,200 children in the care of child, youth and family, which really highlights the inadequacies of the way that we deal with children in foster care in particular. I acknowledge the work that the Minister has done in terms of continuity for children, but I do think that the SIP's number 6 bill actually addresses several of the recommendations that the Children's Commissioner has made, especially around the transition into independent living. I've seen damning cases where 17-year-olds have come out of foster care, have moved into prostitution, or have committed suicide because they have no longer had any support from anyone. Their biological families are not in their lives, their foster parents no longer have any obligation to them nor do SIFs, and they have simply dropped away from the system to the detriment of that young person. Also, children's participation in place and planning decision making, a recommendation from the Children's Commissioner that is in the SIF's number 6 bill. I think if this government is serious about children and young person in the care of SIFs, they would do well to bring that bill before the House so we could incorporate those